Thank you, Real Chair Klobuchar. Macon, it's good to see you back in this room where we spent much time. Thank
Great
you,
to see you,
Professor
Chairman.
Rose and Ms. Schleiman, for joining us today. Mr. Delarahim, in a speech you gave at Duke in 2021, you noted several court precedents that proved to be particularly challenging as an antitrust enforcer. One of those cases was the 2018 decision, Ohio versus American Express, which you said was a classic example of bad case leading to bad law. How did the decision in that case impact your ability to challenge proposed mergers?
That decision, thank you, Chairman Durbin, for that question. That decision was one that was cited in the, I think erroneously at that time, cited in the Sabre Fair Logics challenge, where the division brought, and an incredibly bright judge looked at that, and it's a complex case. It looked at the market definition and made it very difficult for the division as a matter of law to go into court, say, you should look at the definition on one side of the market rather than the two sides of the market. It's a decision where, when I mentioned bad case bringing bad law, when I came in, I tried to settle that because I saw the train wreck going to happen at the Supreme Court, the uncertainty of the bad law being made. Unfortunately, it was a case that was, even though it was the Justice Department's case, the state of Ohio was the one that ended up seeking cert. And I was not able to get all the parties involved. The challenge with it is that now you have a law on market definition with two-sided markets that's very difficult to administer. And, it's a great precedent to litigate, but it's just very difficult for enforcers because it doesn't have clarity.
Is the clarity lacking in terms of law and precedent or the complexity of the case?
The complexity of the case. I mean, how you address that, you're going to have to litigate. I believe the judge in Delaware, the Sabre Fair Lodges, I believe he's been elevated now in a court of appeals. Incredibly bright judge. He just looked at it. He said, like, as a matter of law, I have difficulty. Here's how I have to interpret this market or define this market. And that was one of the challenges. These are difficult for the Supreme Court to, two-sided markets are difficult to understand, to really appreciate why two-sided markets are important. Sometimes you have to engage in perhaps restricting some output on one side. For example, Uber is one where if you don't have enough drivers, there's not going to be demand on the consumers who wants it. If you have enough drivers, then, so the two sides are really important. There's an interplay between the two. And you have to factor those both in, as the court mentioned. You can't just say, because you're limiting output on one side, you now have an antitrust violation. And in that case, it was against American Express, who for many years tried to enter into the market against Visa, MasterCard. It couldn't. It set up its own separate network, exactly the type of thing we would like somebody to invest. They got, I think, 24, 25% of the market. There was enforcement actions against Visa and MasterCard, and then we sued for antitrust against American Express by saying that, if you're using my network that I invested in, you can't, direct consumers over that I brought to you to the other side. And I think that was just a mistake in enforcement.
Professor Rose, in an interview with the Harvard Gazette 2021, I missed that issue. I'm sure it was sent to my home. You said the case law relating to vertical mergers was too lenient, and decisions have to frequently be based on misunderstanding the economics. Could you reflect on that comment based on the exchange, Mr.
Sure. That's. I'm interested that someone found that article that was when I was at Radcliffe. So here's, I think, what I was referring to. So first, with respect to the economics, there was this, I'll just call it a very naive and formulaic view about vertical mergers that focused on the potential efficiencies of vertical integration and made the erroneous economics argument that in any vertical chain of production, there was at most one monopoly profit, and so it didn't really matter whether that profit was earned at one level or another level. By combining the two levels, you weren't going to increase the amount that a firm could earn. And what we understand as we look at markets where there are relatively few competitors that interact is that that model is just wrong. That in particular, I described earlier foreclosure effects. If I can combine, say, the upstream manufacturer and the distributor, and I can foreclose access to, say, the distributor network to my upstream rivals, and they've got to go through some more costly way, to go back to this discussion of Ticketmaster, they've got to go through some more costly way of selling tickets because they don't have a low-cost ticket option anymore, then I'm able to raise prices kind of at the expense of these rivals who have lost because their costs are higher. And so we understand now that vertical mergers can create the ability for firms to exclude rivals or to raise their costs, advantage themselves in competition, and harm consumers in that way. And I think the problem is that, we talked a little bit about the case law in the merger guidelines. I think they're just citing to Supreme Court. I haven't gone through them with tooth and comb, but I think they're just citing to Supreme Court cases. And there just haven't been many merger cases that have hit the Supreme Court in general over the last few decades, and really nothing in the vertical context since this economic understanding has become better accepted and understood. And so I think the problem is that judges are still disproportionately inclined to say, as the decision in Microsoft Activision was, to cite to quotation after quotation about vertical mergers are almost always pro-competitive, or vertical mergers create efficiencies, without recognizing their ability to harm competition and therefore our need to enforce against them.
Thank you. Thank you, Madam Chair.